everybody. It's Friday. So some things have gone on. And it's kind of like a lot, but also nothing at the same time. A bunch of things that happened that culminate in a whole big, fat, stinking hunk of nothing. More waiting, basically. So, where were we, and where are we at now? Last time, on Dragon Ball Z, one Mr. Kyle Russell Curtis was set to show up to a contempt hearing after Steve had filed a motion to show cause for contempt and civil contempt. The hearing was set for May 11th, which was a few days ago, and he was to show up and explain why he was not in civil contempt. His motion to dismiss the default judgment due to service was denied, and so we moved forward. Unfortunately, Kyle likes to not move forward, doesn't like moving on with his life, and doesn't like losing. So, he, shockingly, didn't show up. Surprise! To nobody. Nobody's surprised. No, nobody is surprised whatsoever that he didn't show. So he didn't show up to his show how he's not in contempt. And the expectations we had... Oh, and also the judge changed. There was a change in who was doing the judging as Judge Gale was retiring, so they brought in a new judge, which is Judge Earp. So, that was last time. Where are we now? So the hearing happened without him. There were some decisions made and some decisions that were set aside. Noting that Kyle earlier on a stream said that he had moved and had been moved for a few months but had not filed with the court decided to file number 60 here. Number 60, they sent the sheriff of Randolph County, do hereby certify that I received a within and foregoing order on amended motion to show cause and notice of hearing on the 20th day of April 2021, and that I was served the same defendant below, blah, 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 blah. That's all blank. Interesting. I have made due search and inquiry and exercised due diligence, but I am returning the order on amended motion to show cause and notice hearing unserved for reasons stated, moved to Riley 4 months ago as per his mother. Public notary, commission. So, they served Kyle at his Pleasant Garden address, and he wasn't there. So I guess what he had said was true. He had moved 4 months ago. So this was April. 4 months ago was what? January, February, March, April. Yeah, 4 months ago. So moved in January. So, somebody didn't update their, Rayleigh, whatever. Somebody didn't update their address with the court as per the court order. So are we going to take bets on, oh, I didn't come to the hearing because I wasn't properly served? So that was something. Here's what the court then decided. Let's take a look-see, shall we? Number 61. Rally. It's Rally? Oh, okay. Just shocker. According to the law, it doesn't matter what your technical address is. State of North Carolina, Guilford County, Stephen McCrae plaintiff versus Kyle Russell Curtis defendant. In the General Court of Justice, Superior Court Division 19, CVS 8163. Order on amended motion to show cause and notice of hearing. This matter is before the court as a result of the court's order on amended motion to show cause entered on the 19th of April 2021, ECF number 57, directing that Mr. Curtis appear at a hearing scheduled for the 11th of May 2021 at 10 a.m. and show cause as to why he should not be held in civil contempt pursuant to Section 5A-21A of the North Carolina General Statutes for failure to comply with the court's partial judgment by default, the judgment entered on the 23rd of January 2020, ECF number 17. The court does not repeat, but incorporates by reference the procedural history in this matter as stated on the court's 19th April 2021 order, paragraph 2 to 11. A. Findings of fact. Mr. Curtis, who is now pro se, registered as a party. Oh, remember why he was pro se? I'm sure you all remember. Mr. Curtis, who is now pro se, registered as a party and created an account for filing materials with the court electronically. When doing so, he provided both his email address and his physical address. On 3 occasions, Mr. Curtis has filed materials electronically, evidencing his knowledge and ability to use the court's electronic filing system. See Order, Compliance, and Financial Consideration Compliance Order, ECF number 18, Motion to Set Aside, ECF number 19, Motion to Set Aside Default Judgment, Revised, ECF number 20. Pursuant to North Carolina Business Court Rule BCR 3.8, Mr. Curtis was notified that the court would transmit all orders, decrees, judgments, and other matters through the court's electronic filing system, which in turn would generate a notice of filing to all counsel and, in this case, him as a pro se defendant. BCR 3.8 makes clear that the issuance by the electronic filing system of a notice of filing for any order, decree, or judgment constitutes entry and service of the order, decree, or judgment. It looks like the court's getting ahead of him trying to say he wasn't properly served because he moved again. Neither Business Court Rule 3.8 nor the North Carolina Rule of Civil Procedure provide or contemplate that any other form of service is required. Mr. Curtis has not moved pursuant to BCR 3.2 to be relieved from his obligation to use the court's electronic filing system. While not required to do so, the court made efforts to have Randolph County Sheriff's Department hand-deliver a copy of the court's 19th April 2021 order to Mr. Curtis at his address of record. An affidavit from the deputy who attempted service states that the deputy was unsuccessful in this effort and was informed by Mr. Curtis's mother, who was present at the address, that Mr. Curtis had moved to Raleigh 4 months ago. See Randolph County Sheriff's Office Return of Service, ECF number 60, which I showed you. Even if true that Mr. Curtis physically moved, a change of physical address does not affect one's email address, and it is Mr. Curtis's responsibility to provide accurate information and otherwise to comply with the rules of this court. Oh no. Raleigh, right, it was Raleigh, sorry, I'm gonna keep saying it wrong. Raleigh. So, good to know that we've got another count of contempt, I guess. The judgment required Mr. Curtis to, quote, return administrative control and primary ownership rights of the Non-Sequitur podcast YouTube channel and any other accounts associated with the party's business endeavor to plaintiff, end quote, paragraph 21, 1. The business endeavor is defined in the complaint as Non-Sequitur, a name used collectively for the Non-Sequitur podcast and the YouTube channel, paragraph 9, ECF number 3. The judgment further required defendant to, quote, provide plaintiff with all financial documents associated with Non-Sequitur's financial affairs and financial condition within 14 days, end quote, of the order, paragraph 21. On February 4th, 2020, Mr. Curtis submitted a document entitled Compliance to the Order, ECF number 18. The document included a summary of some financial information, but no original financial documents were provided. See Compliance Order. Prior to the May 11th, 2021 hearing date, Mr. Curtis did not file any additional documents authenticated by sworn testimony in response to the 19th, April 2021 order. Mr. McRae submitted an affidavit stating his position with respect to the rights of the financial information he is due from Mr. Curtis, ECF number 58. And this is one. The court understands that primary ownership rights is a term of art used by YouTube to determine access and control rights with respect to a YouTube channel. The court, in its judgment, did not adjudicate actual ownership of any partnership assets. So, what that means is because it's a platform, it's an account on a platform. YouTube owns the technical rights to any channel. It's part of the way terms of service works. So the same way like you would own a Twitter account or your Facebook, anything like that, they can get rid of you or give you whatever they want or restrict your access however they see fit because they're the business and you're using their materials. So any YouTube channel is technically owned by YouTube, and then I own my channel under that umbrella, if that makes sense. So it's just like there's an umbrella ownership of all YouTube owned by Google and YouTube, and then you own your individual channel within that sphere. All right. So the court is essentially just making it clear that that's what they mean. They don't say that Steve or Kyle own a piece of YouTube. That would be stupid. Mr. Curtis did not appear for the 11th May 2021 hearing. Mr. McRae appeared through counsel and was heard. Mr. McRae contends that Mr. Curtis's prior submission does not comply with the court's judgment, motion to show cause, paragraph 5, ECF number 23, and that Mr. Curtis has still not complied with the judgment, amended motion to show cause, paragraph 123, ECF number 55. Among other things, Mr. McRae contends that Mr. Curtis provided a list of inaccurate usernames and passwords for accounts associated with non-sequitur and failed to provide any financial documentations. 12th of February 2021, McRae affidavit, paragraph 12 to 17, ECF number 22. Conclusion of law. So that was what's happened so far. This is what the law is deciding. Mr. Curtis was served with the order on amended motion to show cause and notice of hearing scheduled for the 11th of May 2021. So he was served. The purpose of the hearing was to give Mr. Curtis an opportunity to show cause as to why he should not be found in civil contempt for failure to comply with the judgment. He failed to appear. The purpose of civil contempt is, quote, to preserve the rights of private parties and to compel obedience to orders and decrees made for the benefit of such parties, end quote. Till versus Berry 234, North Carolina, App 96, 102, 2014, citation omitted. In its 19th April 2021 order, the court found probable cause to believe that Mr. Curtis is in civil contempt. Well, okay, so yeah, that's the court deciding that Kyle's in civil contempt. See North Carolina General Statute, paragraph 5A-23A. See also Plasman versus Deca Furniture, U.S., Inc., 2016, NCBC Lexus 20 at *6, North Carolina Superior Court, 26th of February 2016. Also Young versus Mastrom, Inc. at 149, North Carolina App 483, 484 to 85. 2002, quoting State versus Williams, 314, North Carolina 337, 343, 1985. Therefore, the burden of proof has shifted to Mr. Curtis to show that he should not be held in contempt, that he lacks the means to comply, or that his noncompliance was willful. Shoemaker versus Shoemaker, 137, North Carolina, App 7276, 2000. To date, Mr. Curtis has not met this burden despite clear opportunity to do so. And there's that nail in the coffin. Mr. Curtis's failure to appear for the hearing, as ordered by the court, particularly when coupled with his earlier failure to respond to the complaint, suggests that he has acted willfully to disobey an order of this court. Probably more than one, but yeah. This conduct raises the potential for the court to find that Mr. Curtis is not only in civil contempt, so they've already found him in civil contempt, for failure to comply with the judgment, but also is in criminal contempt for failing to appear on the 11th of May, 2021 as ordered. So, yeah, if you notice, it's worded really particularly. So this conduct raises the potential for the court to find that Mr. Curtis is not only in civil contempt for failure to comply with the judgment, but also is in criminal contempt for failing to appear on the 11th of May, 2021 as ordered. Were it not for the potential for COVID-19 concerns in this unprecedented time, Mr. Curtis's pro se status, Mr. Curtis's early, albeit insufficient, attempt to respond to the judgment, and it's nice of them to say this was a legitimate attempt and not just fucking with the court and admitting to attempted embezzlement, but okay. And the gravity of the consequences for contempt, which include imprisonment, this court would issue an order to show cause requiring Mr. Curtis now to come forward and show cause as to why he should not be held in criminal contempt for his failure to abide by the order to appear on the 11th of May, 2021. So, let me just finish the paragraph and then I'll kind of elaborate a little bit. However, under the circumstances, the court will schedule a second hearing to afford Mr. Curtis a final opportunity to either comply with the judgment or appear and show cause as to why he should not be held in civil contempt. So, as of right now, if this makes sense, as of right now, the court's saying, you're in civil contempt. We are giving you one last opportunity to show up and explain how you're not in civil contempt, why you didn't show up, and tell us also why you aren't in criminal contempt at the same time. If that makes sense. Now, let me tell you why this is bullshit. It's been 2 years. Part of the court's duty, part of the job of the court, is to protect the plaintiff from the defendant in certain cases. In all cases, they're supposed to, if the defendant is causing harm to the plaintiff. In this case, the court has done nothing, zero, to protect Steve, who is the plaintiff, in any way, shape, or form. Kyle is a liability to not show up. Kyle is a liability to run. Because if you're not including this bunch of not showing up, so he didn't show up to the hearing. There were 3 or 4 times he had opportunities to file and never did. Then there was didn't comply with the order, didn't show up initially. He's not going to show. Now, he's also been running his mouth, and he's also done everything. I didn't do it. I didn't knock anything over. I don't know what you're talking about. Rude. There's... What was I saying? That completely threw off my train of thought. Kyle has been running his mouth, and he has been doing everything that he can to do what is, at this point, intellectual and property damage to the show, to slander, libel, etc. Steve, to try and do as much damage as possible, to try and prevent Steve as much as he can from being able to move on with his life. This is emotional, psychological, and as much physical harm as possible, because keep in mind, when you're withholding money from somebody, you're withholding them from being able to do whatever it is within their life. That is physical. So you've got a situation where the court is doing and has been doing nothing and allowing someone who has been found to be a criminal, who also, by the way, had a failure to show up the first time he went to jail. Because keep in mind, not forgetting, Kyle is already a felon. You didn't see me do that. It was off screen. You don't know. I don't know what you're talking about. Kyle's already a felon. He's tried to attack Steve through false copyright strikes to prevent him from streaming and affect his livelihood. He's also tried to do as much damage to the channel as possible. He's also got people that he's working with to go and whisper in other people's ears to try and slander and do as much damage as possible to stop people from doing whatever they're doing and interacting with Steve however they're interacting with him. Cyber stalking, cyber bullying, cyber harassment, however you want to put it, all the above probably, etc., etc., etc. The depths of which this goes, we won't really know until we actually get the stuff back. Now keep in mind, all of this is still any of this going to the DA, the district attorney, because you've now got criminal contempt that he now has to show up to explain. And if he can explain why he's not in criminal contempt, they're giving him the opportunity to one last ditch effort to explain what, because they found him in civil contempt and they're just saying, listen, you are currently in civil contempt. We're going to give you one last opportunity to explain why you're not in criminal contempt. And if you can do that, we'll listen to you explain why you're not in civil contempt. If that makes sense. Now, compliance with the judgment requires that Mr. Curtis produce the following information and take the following action. A. Provide all current usernames, passwords, and multi-factor authentications necessary to return primary ownership rights and administrative control of the Non Sequitur Show YouTube channel and podcast to Mr. McRae. B. Provide original financial documents for all revenue resulting from the Non Sequitur Show regardless of the source of that revenue, e.g. YouTube, Patreon, Teespring, PayPal, Streamlabs, Redbubble, AdSense, podcasts, etc. Provide original financial documents for all expenses incurred and paid for the Non Sequitur Show and for any revenue generating activity relating to the Non Sequitur Show. D. Provide copies of all federal, state, and local tax records reflecting income earned from the Non Sequitur Show and activities related to the Non Sequitur Show. E. Provide bank statements for all accounts to which either revenue from the Non Sequitur Show was deposited or expenses for the Non Sequitur Show were paid. F. Provide a sworn statement made under oath under penalty of perjury. Because, he needs more perjury on his record right now. Provide a sworn statement under oath under penalty of perjury that the documents and information provided are true, accurate, and complete to the best of his knowledge, information, or belief. The court notes that its only means of compelling compliance in a person found in civil contempt is imprisonment as long as civil contempt continues. Red Valve Inc. versus Titan Valve Inc. 2019 NCBC Lexus 57 at asterisk 79, citing North Carolina General Statute, paragraph 5A 21B. As such, Mr. Curtis should be prepared to be placed in the custody of the Sheriff of Guilford County should he not comply with the judgment and the court make an appropriate finding of civil contempt. So this means that they haven't, because they're giving him the opportunity, it's not on his record yet. They're saying this is what you're currently in. We're giving you this last opportunity to explain why you're not. So that's why it's make an appropriate finding. It's the same way of having like a partial judgment. So they're not hitting him with the book yet. They're saying you're in civil contempt. This is why you've got people getting confused to say that, oh, well, the court hasn't found him guilty yet. Well, no, the court hasn't found him guilty of anything. That hasn't come up at all because that's just not the way this functions. And the thing is things that are... The court system has a very particular way of going about things that isn't the same as in your day-to-day life. The court is affording Mr. Curtis a third and final opportunity to comply with the judgment and, failing compliance, a second opportunity to show cause as to why the court should not find him in civil contempt. That's the court giving him everything. This is his opportunity. If Kyle wanted to get out of all this, this is his opportunity. If he complied with everything on that list before this, then they wouldn't be finding him in civil contempt. This is the court giving him that last-ditch effort to be able to get out of contempt, to get out of everything. This is the 21 right here. This is a get-out-of-jail-free card, literally, because otherwise he's going to go to jail. This is his get-out-of-jail-free card. Listen, you have a third and final opportunity to comply with the judgment. Do it. Because if you do, we're not going to find you in contempt. But failing compliance, you will have a second opportunity to show cause as to why the court should not find you in civil contempt, at the same time as why you explain to us why you're not in criminal contempt. Should Mr. Curtis fail to make good use of this opportunity, the court is prepared to move forward with criminal contempt charges. There you go. Under now again, none of this, 21 here, this is a godsend for Kyle. This is a godsend. This is his only and last opportunity, according to this. And this is, again, like I said, literally a get-out-of-jail-free card. Does he deserve this? No, but the court isn't always necessarily about punishment. The court's job is to rectify the situation. The court's job, it's not the court's job to go after Kyle and punish him for how everybody feels. Yes, we're all angry. Yes, we're all frustrated. Yes, we all deserve a little bit of vindication. And yes, we all deserve to have the show back and Kyle go fuck himself. But that's not the court's job. The court's job is to resolve the situation. This is their attempt to do so. Do I agree with them? No, but you kind of got to accept that it is what it is, because unlike some other crazy people, we accept the court's judgment in this case, and we're not crazy, and we're not going to pretend that it's something that it isn't. Kyle, here's your get-out-of-jail-free card. Take it and go, and give Steve his shit back. Kyle's Goldfish says not a chance he can comply with that list. Any monies which were there are gone, and if he provides financials, it's going to be evidence how much was and should have been split with Steve. Even if he tried to provide it now, he'd only be making it worse for himself, since it'll show the amount of money pilfered away. He's going to rely on the court's guesstimating an amount and Steve. That's a mistake on his part, which I think you would agree with. Giving Kyle more and more time to fuck over Steve isn't justice in your opinion. I agree. The court has done nothing, and you'll notice the court has done nothing to protect the plaintiff in this case. Zero. Now, is that because they're incompetent? Like, they don't know how? Because they don't understand what's going on? Because it is a precedent-setting case? But for all we know, they're going to put in residuals to try and make up for it. Who knows? Who knows? It's hard to say. The court specifically had not adjudicated ownership of anything. You can't say it's Steve's. Yeah, I can, and I did, and so did they. Like I just said, there's a handful of crazy people that seem to just deny completely what the court is saying. We're not going to do that here. We're not going to deny that the court is giving, although what we may think is an unfair and unreasonable get-out-of-jail-free card, it does exist. It's there. It's black and white. Number 22. Under North Carolina General Statute, paragraph 5A-11A3, a court may find a person in criminal contempt for the willful disobedience of resistance to or interference with a court's lawful process, order, directive, or instructions or its execution. End quote. Next quote. Willfulness in the criminal contempt statute means an act done deliberately and purposefully in violation of the law and without authority, justification, or excuse. End quote. So, for example, telling the court to go fuck itself because they think he might have done something wrong. State versus Fair, 193, North Carolina App 591, 594, 2008, quoting State versus Trisco? I don't know how to say that. 85, North Carolina App 155, 158, 1987. Our Court of Appeals has also stated that the willfulness element of criminal contempt, quote, involves more than deliberation or conscious choice. It also imports a bad faith disregard for authority and the law, end quote. Again, refer you to Kyle telling the court to go fuck itself. Fort versus Fort, North Carolina, 65, North Carolina App 615, 616, 1983, citing Mauney versus Mauney at 268, North Carolina 254, 1966, West versus West 199, North Carolina 12, 1930. Quote, any criminal contempt other than direct criminal contempt is indirect criminal contempt and is punishable only by proceedings in accordance with the procedure required by North Carolina General Statute 5A15, end quote, North Carolina General Statute paragraph 5A-13B. Whew. Should Mr. Curtis fail to comply with the judgment on or before the date of the second hearing, he is expected to appear in person and to show cause as to why he should not be held in civil contempt. Failing compliance or appearance, the court will issue a second order to show cause, this time for criminal contempt. A preliminary hearing will be scheduled, and the court will determine if probable cause exists to issue an order of arrest. 21 man, your get out of jail free card. Good luck, my dude. The court again advises Mr. Curtis that imprisonment can be a consequence of a finding of either civil or criminal contempt, and that he has the right to counsel. Should Mr. Curtis elect to retain counsel, they're giving him another opportunity to get a lawyer, he should do so promptly. Counsel is directed to file a notice of appearance at least 2 business days prior to the hearing. The court reminds all parties and counsel of their obligations at all times to ensure that their contact information, including their physical addresses and email addresses, are accurate and up to date with the court. Steve, you better not move. Conclusion. Wherefore, the court orders that defendant Kyle Russell Curtis shall appear before the court to show cause as to why he should not be found in civil contempt for violation of the court's judgment at 10 a.m. on Wednesday, the 26th of May, 2021, in Courtroom 3G at Guilford County Courthouse, 201 South Eugene Street, Greensboro, North Carolina 2741. The parties are directed to promptly notify the court in the event Mr. Curtis produces the information described in paragraph 19 above. It is so ordered this the 13th of May 2021. Juliana Earp. So that's the new judge. And it is currently the 14th. So there are, what date was that? That said the 26th. So that is 2 Wednesdays from now. There are 2 weeks. So we are 2 weeks out from, doing this whole spiel again and having Kyle not show up again because the court, for some reason, likes getting fucked with. Why does these two judges enjoy getting fucked with so much? I think it's pretty clear why this is bullshit, and ought to be viewed as such. And if I were Steve or Steve's lawyer, I'd be filing a complaint. At this point, I'd be filing a complaint as to how this court has been, at the very least, dismissive of the damage and ongoing damage, or neglectful of their duty to protect the plaintiff in this case. That's what I would be looking for. Again, none of this has to do with what's going to end up going to the DA, or more likely to end up going to the DA, I should say. So we'll have to see. So I don't think anybody's happy about this. I mean, nobody ought to be happy about this because this is just dragging on nonsense for no reason. So what? We can repeat the same thing over and again in 2 weeks. So hopefully they'll follow through with, if Kyle doesn't show up to show why he's in criminal, to then show why he's in civil, or why he's not in criminal, why he's not in civil, and blah, 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 blah. I don't think he's going to show up. the fact that he's already not shown up enough, and the fact that I would probably, if I were the court, I'd consider him a flight risk because he didn't change his address when he moved. We'll see how fast this, what happened to justice delayed is justice denied. Yeah, this to me, all of this is just delaying things by 2 weeks for no reason. But if you guys are unhappy, I get that. I understand your frustration. I'm there with you, and I'm sure everybody else is too. I'm not going to look at this as a win, because I don't think this is a win. I think this is just a delay. More delay, with Kyle getting one get-out-of-jail-free card, which he's going to be too stupid to take, and everybody that's been supporting him or encouraging him this is too dumb to actually encourage him to take, because fuck justice and fuck what's right. Fuck morals, I guess. Anybody who is behind, anybody who would like to catch up, I think there was somebody in here, Mr. something, Mr. Brian or whatever, whoever that was. I recommend you take a look at all of the videos and get yourself caught up. You seem a little bit behind, you're missing out on a few details, or you've got some details confused. So I'd recommend maybe taking a step back from wherever you're getting your information. Either read it yourself directly, or take the opportunity and, if you don't have time, listen to me read it directly and see what's actually in black and white. Take a look at it objectively and see how it actually looks. 2 weeks. The court finds that Mr. Curtis should be given 2 more years to dink around. Yeah, pretty much. We'll have to see what happens from here. I will continue to follow this, and as we go, I'm on it. I'm gonna keep going. I ain't stopping. I'm on this train. I want to see where this goes. I'm riding this rail all the way to the end. I believe. But that's it for me. Thank you everybody for coming. Like, sub, share. If there are people who are confused, or you find people are confused, send them this way. Everything's all written out for them. I definitely recommend checking out Kyle making his intentions incredibly clear, even right out the gate, if you want to go check out back at the beginning. If you would like to join us in a little bit in-depth conversations, join us on Discord by either becoming a member or becoming a Patreon. I'm gonna go boop my dog Snoot. You guys enjoy booping your buttons. Puck's in the chat. And I will see you guys on Monday for Judgment Call. So if you do have any questions about stuff like that, Judgment Call is an open call-in show. So I'll see you over on Steve's channel at 2 o'clock on Monday. Have a good night, everybody. Bye.